I'm Keith Hutchison. I'm partner in Clyde Co's Middle East Dispute Resolution Group, Litigation Group, however you want to. And Clyde Co as a whole does this kind of specialist recovery work globally as well. But here it's a big part of what I do. So I've got lots of experience in 8 years here of dealing with these kinds of cases. And our objective in all of them is to try and get a resolution, get payment without litigation, without recourse to the courts, because, as I'll come on to tell you, it can be a very unattractive process in this jurisdiction and other jurisdictions in the GCC to actually get involved in court battles. So where we're coming from in all of this is trying to resolve and get payment without having to go that far. So it's an amicable process. I'm joined as well today by Richard Bell, who's one of my partners from our Abu Dhabi office, who also does litigation and some debt recovery work. So in terms of what I hope to cover in the time today, it's necessary, unfortunately, to give you a little bit of a summary of the legal system here, the legal landscape, because that gives context to everything that follows in terms of how we approach debt cases and what your rights as a creditor may be here, and if things don't go well, where you might be looking to end up at the end of the day if litigation was something within your sort of field of view that you might want to pursue. You need to know from the start, when you embark on a strategy, where might it all end up if it doesn't work out. So that's why I'll cover that. We'll then look at the recovery approach that we generally take on cases. I was talking to someone just outside. It's very much here a case-by-case basis on how you approach anything, because each debtor responds differently to different tactics, depending who they are, who owns them, your commercial relationship. But by and large, there are some general themes you can follow that we've found are successful in this region for actually recovering. You can never recover everything. I don't think you can't guarantee you'll always get your money back or 100% for various reasons, but say there's themes you can follow. Litigation issues is just some of the things that I'll tell you are problems and idiosyncrasies of litigation in the court system here and how it's set up. I can cover a bit about bounce checks. That's quite a big theme here. People writing checks, as I'm sure we're all familiar with. We get asked to write checks for various things personally, and businesses. There's still, within the UAE, a lot of trade is facilitated by checks. Not so much internationally, because people tend to use other financial instruments for that. But in terms of local work, bounce checks is quite important as leverage for being able to recover money. Case examples I can give as we go through. If people have particular examples they want to ask a question about, then please feel free to do so, and we can deal with those questions as we go. So, as I said, to put in context everything that follows, how does the legal system of the UAE look without getting too much involved in the laws? So it's a civil law system here as compared to a common law system, which is the system where I come from in England and in many other sort of Commonwealth jurisdictions, so Australia, Canada, the US. These are considered common law systems where the law is developed not only in written statutes but also through how the courts interpret those laws and make judgments which then form part of the law and develop it. Here we're a civil law system with codified laws where all the laws that there are written down in some form or other. You might not always be able to find them or know when they've changed necessarily. There's lots of laws always in the draft stage with the government, particularly at federal level, and some of the most important laws we've got here are actually quite antiquated. So lots of the commercial laws here are 10, 20 years old. Even I think that the civil code, although it's been overhauled, the civil procedure code has been overhauled very recently. The civil code goes back to sort of the 1990s, and lots of commerce is still done around the provisions of that, and they haven't really caught up so much with other modern financial centres. So you're looking at a system where everything you should need to know is written down somewhere in a code if you can find it. Civil obligations, which is what you're looking at in debt situations, is contract really, where you agree to provide goods or services in exchange for payment. It's as simple as that. It's contract. There are other laws dealing with other obligations, but that's your focus. There are general laws that deal with, so the civil code is general provisions of how parties interact, rights, obligations. There are more specific sections within there that deal with particular types of contract, lease contracts, ownership contracts, bailment, supply of goods and services, transportation, all these kinds of things. There's different sections. There are also specific laws which supplement what will actually, where they apply, they will supersede the general obligations. So sometimes you might need to look for a specific law that relates to what you're doing, and that includes within Emirates as well. Each of the Emirates is subject to federal law at a high level, and then beneath that you have Emirate level laws where each Emirate can legislate on certain things, and you might find that in a particular Emirate, contract law is dealt with slightly differently. So Dubai has its own contract law, for example. Not a lot of people know that, but it's more often people just go to the civil code. That's just how it's done. People often ask us, okay, so isn't the UAE and a Sharia governed by Sharia law? Well, Islam is the constitutional religion of the state, and therefore Sharia principles are relevant. But in commerce, Sharia law doesn't really have much impact in the UAE. In Saudi Arabia, very different. The whole system there is geared around Islamic law. In the UAE, it's only really relevant to family law issues and certain other things that are outside the commercial sphere. So including, one of the big differences is in interest. People often say, well, you can't claim interest here on debts, can you? Because it's haram. And we say, well, no, actually, that's not right. Even in Dubai, in the codes, commercial code, and there's a specific provision that allows you to charge commercial interest for late payment of debts. So absolutely, that's one thing that people are surprised about is, well, interest is prescribed by law that you can do it. Overarching everything else is the constitution of the UAE, which is, applies to all the Emirates, and that dictates certain things that can be legislated on by Emirates and certain things that can't. Not really relevant in a commercial context, but it just tells you how the structure sits with the laws. I've mentioned that the laws are generally commercially unsophisticated, which puts you at a bit of a disadvantage as a creditor in terms of the tools that you have at your disposal to enforce rights. The remedies that you might expect in more developed jurisdictions just aren't available to you. And if a debtor party who's not paying you is at all aware of this as you will be, then they will know that they can play sort of silly games and try and dance around paying you because they know that the laws aren't really in your favour to help you so much against them. Big problem sort of at the end of the rainbow would be in other jurisdictions, a creditor might look to insolvency procedures as a maybe a last resort of actually getting someone to pay, or as a threat that if ultimately the debt is large enough, we can threaten you with winding up, liquidation, shutting your company down if you don't pay us. And in other jurisdictions outside this region, that can actually be very effective, and it's very cheap and easy to file applications with courts to close a company down if they don't pay you. Here, that doesn't really apply because the insolvency laws are made up of a handful of provisions in the general laws relating to commerce. There's no standalone insolvency law that helps creditors say, this person can't pay its debts, therefore I want you to order them to be shut down if they don't pay. That apparently is going to change sometime. There's a draft federal insolvency law that has been talked about for many years, but it's one of those things that none of us have actually seen, so we just carry on with what's there. Again, I was mentioning to someone out there, in terms of how the legal system works, there is no binding judicial precedent. For non-lawyers, that means that where a court decides a case where the court gives judgment on a particular case, on a particular legal point or issue or circumstances, which could be replicated in another case, that previous decision of the court, even if it's the highest court in the UAE, does not bind a later court to follow that same decision on what the law means. So you don't have the benefit of being able to just go to a debtor and say, well, our circumstances match exactly this case which was decided several times by the highest court in a court of cassation, therefore if we go to court you're bound to lose. In other jurisdictions where you do have binding precedent, you can actually use that to your advantage to press someone to say you've got no chance in sort of defeating my claim. Here it's very much a case-by-case basis, although we're moving towards more of a system where courts will take some recognition and be persuaded by previous cases on particular issues. So again, this is all not to be lecturing you in law, but just to be setting the scene as to how the jurisdiction is set up for this kind of thing. And this sounds like a bad news story, but another thing that's difficult here in this jurisdiction is that there is generally no, what we describe as a summary or expedited process in the courts. And that there's one exception to that, which I'll come on to. But again, in other jurisdictions where you may be familiar with, there is often a judicial procedure where you have, most debt cases are fairly straightforward with, you agree to provide goods or services, you provide them, you supply them, you've performed, you should get paid, okay? Fairly simple obligations, no big, huge, complex construction project or anything, lots of variables. In those kinds of cases, a debtor doesn't really have a defence in law. They may be just saying, we can't pay you, oh, we haven't been paid by our onwards seller, our onwards customer, even though there's no back-to-back clause that says they must be paid first to pay you. Common excuse we hear here for people with debts, oh, sorry, I can't pay you because I haven't been paid. That's not our deal. That's between me and you, so I don't care. In those kinds of cases elsewhere, you might be able to go to a court and say, this is the situation, here's my contract, please can I have a judgment now without any long-winded, costly trial that I can then execute against them in the execution courts. And those sorts of processes are available in other places on certain facts. Whereas here, there isn't really any process that allows you to do that, and you're left with your only realistic judicial option is litigation, which comes with all of the issues and consequences we'll come on to, and it's not very attractive, not where you want to be. And here they're very generous, they're good for creditors because they're either sort of 10 or 15 years really for most commercial claims. So you don't need to worry so much about your current book of debtors because you're probably well within the 10 years. That's the legal system in a blast through. Debt recovery, the general approach, I've said it already, and this is the real emphasis of everything and probably be music to your ears, that the way we approach things is that the amicable resolution in this region is far and away the best sort of approach to take from the start, that is your objective. You don't necessarily portray that to your debtor, but in your own mind be thinking to yourself from the start, would I go to litigation on this case or not if it gets difficult? Probably not for the types of values you're talking. So always be thinking amicable resolution. And that's how we approach cases when we deal with them. We'll be aggressive where we need to be, depending on how the clients want us to treat their debtor, but ultimately we're looking to try and resolve it. Lawyers don't, it's not in the client's best interest always just litigate. It's resolution that's acceptable to you, and that's the key as well. Any solution that's agreed amicably is acceptable to you. You might not be delighted about it, but when you're thinking about recoveries, is 100% what you absolutely must get, or will I accept and walk away feeling all right about 50% or 60%? So you always have to be deciding these factors, balancing them against the risks legally. So we find here, and probably it's an obvious one, but communication with the debtor is the absolute key. And we find that more so than writing emails and letters and faxes and using standard sort of 30-day, 60-day, 90-day letters that just go out on those automated dates almost there or thereabouts, that communication orally, so lots of telephone calls. We get great success from, hounding is probably putting it a bit harshly, but regular follow-ups to people, showing them we are here, we're on to you, we're not letting go. We don't wait 20 days from one call to the next. Once you put your demand out there that someone's in default, communicating with them constantly, not always aggressively, but just letting people know you're there. All companies, sometimes we're on the other side where actually we've procured a good or service, and put yourself in the other party's shoes and think, well, when I get a call saying, oh, you've got us to do this for you, you owe us this much, you kind of, if someone's calling you, it gives you a different thought process than just getting an email amongst hundreds or a fax or something. You just put it on your pile and go on. So communication and actual personal communication, here that has the same effect in a lot of aspects of business, to actually the amount of face time. If you can see people, great. It's not always possible to go and see people. You haven't got the time, haven't got the money, can't do it. Phone helps go a long way. From the outset, know your commercial position under your and legal position under your own terms. What do your terms actually say? We get lots of clients come to us saying, oh, we're struggling to get this, that and the other, and we say, what do your terms say about disputes and governing law and the ability to charge interest, and what can you do if you're providing a service? Can you stop it? Can you terminate? Can you suspend? and we're sort of aghast sometimes that people don't even know their own terms. So always be aware at the start, what are my rights, what can I do here, so that I know I can plan my approach with this debtor. A key, again, from the outset, is to know why. Why is this not being paid? Ask the question, probe this debtor. We face, I'm sure you've heard them as well with problem debtors, that there's a raft of standard type excuses that you'll get from people. I've not been paid by someone, we're in financial difficulties, it's a bit difficult for us in the market at the minute, we're not able to shift these units, or we're changing our bank, our management's changed, they say they know nothing about this debt, they say it's nothing to do with them, we're just washing our hands of it. Well, you need to sort of pick your way through all these excuses and really push them and say, and we'll always say before we go back to clients, okay, we're not just going to report an excuse. I'm not going away, Mr. Debtor, unless you tell me with reasons and with evidence why you say that is so. I'm not taking your word for it. And that's the easiest way out for debtors to keep pushing people away, is just to say something and someone says, oh, okay, I'll call you next week then. You need to push these people and don't take an explanation or an excuse without asking for evidence and be saying, actually, okay, fine, I'll take that at face value, but unless you provide me with some concrete evidence in writing, or I come and meet with you and I meet with that person who you say controls that part of your business, your finance director, I'm not going to accept it, sorry, and we're going to go to the next step. What do you want to do? So that's the kind of approach we'd advise taking. Now I know that there's many difficulties in the conflict in businesses between sales and collections. So you've got the accounts receivables guys have to be careful not to upset commercial relationships, because their sales guys are saying, oh, don't, that's my account. And there's even more difficulties if you have a hybrid role of the sales guy having to actually do the collections as well, because they're inherently conflicted of not wanting to upset their customers to win new business, and they sort of forget about the old stuff just to get the new business. Try and divorce them as much as you can, but commercial relationships can be great leverage for collecting money, because you can turn the taps off of providing services. If it's lease, if it's rent payments, then you've got landlord rights to do certain things. If it's content services, you can pull the plug or suspend it, and that is great. So always understand from your salespeople or other people in your organisation, what relationships do we have here to leverage? And it might not always be at the level you think. You say, well, so-and-so actually knows someone in their finance department or one of their directors, maybe we can go there. It's all about finding the person within an organisation who either holds the purse and can actually get you paid, or can talk to that person and can influence them, and that there's enough of a relationship between you for ongoing business that you can leverage that. There comes a point, and again, I was talking outside about it, there comes a point when you reach a line where that no longer is a factor that should persuade you, because at the end of the day, we're all businesses, none of us are banks, we're not here to bankroll other people's businesses, and you have to collect at the end of the day. So, but always look for that first, because obviously your shareholders or your management might not be too happy if you upset big clients. So difficult balance. Evidence in this jurisdiction in terms of your documents to support your claim is key, because if you do, one, in terms of presenting it to the person who you're asking to pay, it might not be the person who was around in the debtor organisation when the business was done. So you need to be able to go to someone as if they've never seen it before and say, here's my claim, here's the contract, here's what you agreed, here's emails saying you don't deny it, that it's yes you'll pay, you'll promise. Here it all is on documents, there you go. If you went to court, you'd have to produce all these things to be able to prove your claim, because the courts here are hugely document dependent, and you need to have as many original documents as you can to avoid someone saying they're all fakes, you shouldn't take any notice of those. So having good document procedures, this sort of is rolling backwards to pre-contract, or having good procedures in place to keep documents and keep a trail, because ultimately you will need it. And that's something that you can use in persuading a debtor, say, I've got everything in original form that you signed for delivery of, or we've got the original contract which you stamped. It was signed by your authorised signatory, because we saw he was the general manager on your licence. We've got all the documents we need. So just be mindful of the fact that you need documents if things go bad and you actually need to put a claim into the court. I've mentioned interest already, that it is absolutely legitimate to claim interest here, but people are very reluctant to pay it. They will always say, well, okay, fine, we'll agree some deal on paying you the principal amount back, but you're not getting interest, even though your contract says upon late, you're entitled to interest at X% for non-payment. It's very rare, actually, to be able to recover amicably interest, and that's often something that I would call a concession point, that initially you'll go for the full 100% principal plus interest plus some of your maybe time and cost you've spent on it as your starting point, and then maybe be prepared in negotiations to concede interest as it's an easy one for you to give away because you have a legal entitlement to it, but you can build it up as a huge concession. Okay, I might be prepared. Interest can be significant over a period of time. In some big high value cases, it could exceed the principal amount if it's compounded, for example, in your terms. Another factor is proportionality, which is always a consideration in legal cases. What would be a disproportionate amount of time, money and effort to spend on recovering this debt? Because there comes the point where the balance tips and it's then uneconomical to continue to pursue something, or at least to pursue 100%, which might then, if you took a step back and said, okay, maybe because it's going to cost X, we're never going to get that money back even if we recover the debt. So let's say that our walk-away point is 70% or 80% because that balances off our cost risk. So always be thinking of this factor as well. And if it's something where you did need to go external for help, to lawyers, for example, what's that going to cost us? How does that sit compared to the debt value? Is it at all worth it for us to go externally in this, unless there's some fee arrangement that works for us? The commercial relationship points, and in terms of strategy, is all about a phased escalation of measures against somebody so that they see from you that at each level there is a proposed next step that you will take if they do not pay. And it's very important strategically that if it comes around that they don't do what you're asking, that you do then follow through with the escalation step you're saying you will take, because we see time and time again cases where creditors will be writing to their debtors, just not really much on the phone again, but writing saying, oh, you're very bad, you haven't paid us, if you don't pay us we're going to sue you. And that'll be one of the first things they say. And then time comes round, they don't pay, then they don't sue them. And the debtor thinks, well, that was just hot air, they're not going to actually go through with it. Then more letters, more talking. So you've already laid your sort of strongest card at the start, and then you haven't backed it up. And then people really know that they probably haven't got the conviction to do anything, so I can just ignore them and actually deal with the people who are suing me or not. That kind of thing actually is quite important in markets like this. And the way we tend to deal with gradual escalation is, in general, not applies to every case, is an initial client comes to us, they've not been able to collect for their own internal period, then it comes to us, client might have threatened certain things, but comes to the point where going external to lawyers suddenly is a big sea change in how you're approaching something, because it's quite easy to sort of ignore commercial correspondence, but then suddenly a law firm coming on shows that you've gone through the trouble of instructing a lawyer, briefing them, and they're now involved in writing to you. Still doesn't mean you'll necessarily go on to sue them, but it means that they'll suddenly think, okay, this is actually serious, I need to deal with it. Maybe they instruct their lawyer, and then you have lawyers dealing with each other. And then you see if a resolution can be found, if the value's there. Often taking an objective step back with independent advisors can actually bring people to a mediated solution or something that's acceptable to you, rather than commercial negotiations which have stagnated, otherwise you wouldn't be looking for external solutions. Again, but gradual escalation, and I'll take you through in a later slide some of the other tools we use here to do that. Again, a general strategy point, in in every case, we always think of what are the prospects at the start, because that do we think realistically you stand a good chance of success at the end if you were to go to court or through amicable means. Some cases it's immediately obvious from the start that someone's belligerently saying, you know, I'm not paying you, go away, you're going to have to sue me. And they might have said that in no uncertain terms. And you might need to think at that point, actually, should we waste time trying to settle this out now, or should we look for something stronger like litigation? Always assess at any point what's real, what's realistic here. And I've said already, litigation is a last resort, even coming from a litigator. I don't know if Richard would have a different view, but we'd never really advocate litigation as a strategy from day one. There's times when it's suitable, but for debt recoveries, generally you'd be thinking absolutely.
If I was out of a job, I'd be absolutely delighted. I've something else to do with my life.
Okay, so how do we understand prospects at the start? So knowing your debtor is key. Relationships with some clients will be stronger than others. Who in your organisation, as I said, knows this person, knows who we can talk to? Are they someone from market information, has money? Can they actually pay you? Does that help you assess? Do you have information from somewhere other than the debtor themselves that allows you to assess whether what they're telling you is accurate or not? And I'm sure you all know people in the market who know certain companies, and often if someone is in trouble as a debtor and they do have financial problems, you won't be the only person who's chasing them, and we often have sort of multiple clients coming to us about, and it turns out, oh, it's all about the same party, and then suddenly the news is, well, there's a ton of other people chasing this person as well. That applies when a debt has already arisen, but also in advance, part of your contractual due diligence, in whatever depth you do it. Know who you're dealing with and try and get as much info about their credit record, which is hard in this jurisdiction without any formalised sort of credit bureaus or very limited company information available publicly. So pre-contract due diligence, important. It's amazing how many cases we get that are handed to us maybe a year old, so you know, plus 365 days or even plus 180 days. And the client says, well, we haven't heard from them in a while, we've been sending emails and faxes, but they've just been ignoring them, so please can you take over? And we'll look into it and we'll find their license is expired, they're gone. We'll send someone down to the known address, empty office, dusty desks, nameplate removed, you speak to the guards in the office, the security men or the reception, where's this company? Oh yeah, they've disappeared 3 months ago. No idea where they've gone, they've probably just disappeared. They won't have been formally liquidated probably, because that doesn't really happen here under the laws. They're just, unfortunately, it's not a difficult jurisdiction in which to sort of shut up shop and disappear and go off and do something else without fear of legal reprisal, unless you're a director who's done naughty things and been fraudulent and done things like that under the criminal law. It's very hard to actually track down shareholders and directors and try and get them to be liable to pay the money to you. So actually, it sounds silly, but is it actually still operating and existing? Do you know that for a fact, or have you just been sending unanswered correspondence? Simple things can make such a big difference. Just having the right details for getting hold of people. Sometimes we'll take over, 50, 60 cases from one client. They say, oh, all these people are saying they're not going to pay. And when you look into it, actually, there might be 10 of them that they just didn't have the right email address or fax number, or person had left and there's someone else and the emails were just not going anywhere. You can't just rely on information that's given to you and think that someone's looking at what you're sending. You need to be sure that you're only sure when you get a response or if you speak to somebody. But that's a real simple win. Just make sure and that's a database thing. It's not just the debt collection, it's pre-contract. If we've got everything right from the start to make sure that if there's something wrong, we've got the details right. Of course.
Does it still exist?
Yeah.
If it doesn't exist, you have a contract with that company,
Mm-hmm.
but you know that that director or general manager has moved to another company, can you still go after that person or not?
No, so the liability is with the entity, and there are a few, so you can't then go after, shareholders are only liable in a limited liability company up to the sort of their maximum paid up share capital. And for the management, there are certain provisions duties that directors owe to shareholders, but also if a director has acted in any way fraudulently in defrauding you as a creditor, in some way acting personally, then there might be scope for you to be able to try and wangle some line of attack. That's not to say that you don't pursue, if you know where that person is, that you don't say to them personally, you can't say to them, we will absolutely sue you because you're liable for these reasons, but you might be able to twist them. And we've got cases where a business may have been shut down, so it's not formally liquidated, but they're not trading, and we've still managed to get the mobile of the director or one of the managers, or a local sponsor or something. You'll go to them and say, look, this is what's happened. We know your company's not trading anymore, but we're not going to stop here. This is worth enough money for our clients to come after whoever was involved in it. We don't need to go into the detail of whether actually there's a case we'd win in court or not, but sometimes you can press people enough to say, okay, look, I don't want reputationally to have this hanging over me, although I have no liability, I'll pay you off for this much. And sometimes in those cases where it's almost a dead prospect, anything you can get back is good, right? You might have written it off as a bad debt, and then it comes back in straight on the bottom line as profit if you've already written it off. So absolutely, but that's a prospects thing. You assess it, say, is this person even likely to do anything to pay me? Sure.
The current owner or director, what happens is, once he knows that there are a lot of debts around, he transfers his ownership to his wife.
Mm-hmm.
Okay. And then he says, look, I'm not responsible, it's all sold off, and I'm not the new owner right now.
Do you mean you just transfer shareholding? Yeah, I mean, in terms of going after shareholders, again, unless there's you still have the concept here of a corporate veil where shareholders are protected from the liabilities of the company as a whole, and unless there's some kind of fraud that we can conjure up in the facts to be able to say that this person has deliberately conspired through some transaction to avoid a liability, then it's very difficult to go after the wife or the individual. If it's the company, one of the ways you get around this is to have personal guarantees at the start of a transaction, so that the directors, you lock them in personally by having them sign up to guarantee either a cheque or an actual written guarantee that says, I'll agree to back up the liabilities of this company. Then you can go after them personally, but just transferring a shareholding, it doesn't really help you. Now, one thing that is a growing area in this region particularly now is credit insurance. Now I've put export credit there, which is obviously sort of exporting overseas or outside the jurisdiction, but it's now becoming something that lots of insurance companies are starting to offer as an insurance product for businesses, of which there are many different types of commercial insurance. One of them is credit insurance, whereby if you're selling goods or services to someone on a credit basis, which is what lots of us have to do these days, without any form of security, you can actually get insurance for that, which protects you in the event of a payment default. Okay, there's obviously insurance, terms and conditions, exclusions, etc. But you can get reasonably priced credit insurance to protect you for your business. And a number of insurers do that. They help you with due diligence because they will only insure certain transactions or trades if they've already looked into the quality of your debtor, and they'll do some of their own due diligence. So some of this work they do for you, yes, and you're getting protection if there's non-payment, and if there's non-payment, it doesn't work for things like rent and leases, but products and services, yes, then they will cover you and pay you back, and then it's up to the insurer to actually go off and recover the money. Not your problem so much, apart from your claims record or deductible. But that's just something that is very much a growing area in the UAE at the moment. You also have assistance from trade organisations which might hold records or registrations for certain debtors. So in Dubai, we have the Dubai Chamber of Commerce. You've got a Chamber of Commerce in Abu Dhabi. Dubai is more effective as a source of information than the Abu Dhabi one, we find, but you might be able to find details of contact numbers, ownership, premises, current registrations by going to trade organisations such as the Chambers of Commerce or anything else within an industry to say, do you know if this company's trading, have they changed ownership, this kind of stuff. Anything that can help you find out about who you're dealing with, your counterparty, before and when a problem comes up is useful. Information key. For higher value cases where it's proportionate, to find out whether someone's A key factor is the debtor actually worth the money? Do they have the money? Do they have assets that could actually satisfy a judgment I get against them in any litigation or any dispute? Ultimately, at the end of the day, even if I win, a judgment's only as good as actually the person having money to pay you back if you execute against bank accounts, shares, property, vehicles, movables, all these kinds of assets. Is there value enough in those at the end of the day to get me paid? If it's worth enough money, the case, there's various sort of corporate intelligence agencies here who work to help do lots of sort of digging around to find out who people bank with. I'm not talking about, you know, espionage tactics of going in and James Bond and getting actual bank account statements, because, you know, that's not above board. I mention it again because of the importance. Ongoing relationship with your debtor actually affects prospects. If it's someone you want to continue doing business with currently, then that will probably mean that there's greater prospects of you actually recovering, because you can build in a gradual recovery of current debts with future business in terms of how you structure things. One of the biggest difficulties in this jurisdiction, because of the opaqueness of corporate structures and who's in charge and who's doing what and who's responsible for payments, not always, but a lot of the time, it's getting to the person who actually makes the decision to pay you or not. And we often find that clients will have been passed around the houses within an organisation. Someone says, it's not my responsibility, you need to speak to this guy. Here's his number, I'm not going to help you do it, I know nothing about this. And you might end up going in a sort of vicious circle of everyone referring it back to the next person. You need to get someone to take ownership of it. And this is all about persuasion again. Speaking to people or going to see people and saying, I'm not going anywhere until you get me in front of the person or get them on the phone who actually deals with this and is responsible for it and can take action, or else XYZ might happen. But it's often difficult to actually get to that person. If they're on the trade license, great, you want to try and get to that person. If it's if it's an LLC and it's you want to get to the local sponsor, very difficult to get hold of someone like that. And even if you got their contact details, maybe unlikely they'll speak to you in the first instance. If it was lawyers on your behalf trying to get a hold of that person, they might be more responsive in actually dealing with it or getting someone on their behalf to deal with it. But that's who you need to get to. And businesses will often try and put a barrier up beneath the decision makers to try and stop you from being able to get there. So you need to try and crack through that. And a lot of the way we do that is through our debt team just pressuring people. You know, it's people tactics. A lot of people eventually can be persuaded to divulge information or put you through to someone else just to get rid of you. I've already dealt with this really. Very important to know why they're not paying, because then you can actually deal with it. If they're giving a legitimate reason, how do we work with that? What's our solution to actually getting that payment? It might be, if it's an ongoing relationship, the reason for payment might actually be something that you can help with on your side by speaking to your sales guys or speaking to someone else. If we can do this for them, then they'll probably be able to release those funds to us on that. How does that work? I've already said contract terms is key. What can you actually do under your contract? And are you actually obliged to do anything under your contract as part of an escalation process? Because if ultimately you haven't followed your own terms and conditions, if you did want to then sue somebody, you might then face difficulties because you haven't done what you were supposed to do. So always be aware of your terms. In terms of how do we solidify an agreement? Well, the easiest way is they just pay you and then it's done and dusted. Often we negotiate instalment programs. Sorry, I think that's mine. Normally it's me who has to tell you to turn your phones off. Black mark for me. So in terms of how do you actually record an agreement? Well, what we do is try and get some kind of documented record of in writing what is it this person's agreed to in a written admission to say, yes, I agree, this is the debt we owe you, because that's very good evidence for you in court later if they subsequently default on that. But you're really just trying to get something that it's all well and good saying to them, getting them to agree, yes, we'll pay you 100% in 6 months through 6 instalments, great. And you might think, oh, brilliant, they've agreed to that, I'll forget about that. that will just come in every month and happy, I'll move on to something else. That doesn't work necessarily, because they might just be saying that to get rid of you, and they sign up to something, they don't really care, they don't think you'll follow through. Ultimately, you want to get paid. You don't just want to get an agreement to be paid. So when you're negotiating, is what you're negotiating actually achievable for the debtor? Will they actually be able to pay? And there'll be reasons why they might be saying, we need a year, and you say, I'm only accepting 6 months and that's it. You actually be realistic and think, can they actually afford to pay me in 6 months? Because what's the point in what I'm doing now, unless it's coming in? If it takes me 6 months more, is that acceptable? There's never any guarantee they'll pay you, but you've got to think a bit from their side. Is it commercially, am I doing something here that's realistic for both of us? Otherwise, what's the point? I've said this, written admissions, commitments to pay, will often try and tease out from a debtor where they haven't expressly stated before, we absolutely confirm the debt amount, one, and that we're liable and there's no issue with the product or service. We've got no issue, we just can't pay you. Get that as soon as you can in writing, because you've always got it for evidence later on. And that's one of the first things we'll do. And some of the clients we asked who instruct us actually want that as their first thing they need, is get a written admission from them, because we need it for our insurance or whatever, to show that the amount's confirmed and that the liability is confirmed. That can save you a lot of bother later. Be flexible is this point. Don't just think rigidly it's only about a 100% payment up front. There's many ways you can slice and dice a payment plan, periods of time, values, tied in with new business, just some examples. Look for things like security. Will someone provide you with cheques as part of a payment plan to give you some more assurance that they will pay you? This one I'm going to skim through quickly because the time. This was really just about the legal system. And you have the slides, and I think provided to you to take away, or they will be made available. But it's just sort of saying all of the things that happen if you do have to go to court, and how difficult and time-consuming and costly and everything else it can be. That's not to say the court system doesn't work and that it's not fair. We handle lots of cases where we get good outcomes for clients, but it just takes time, and you need to be prepared to be stuck in for the long haul. And it still doesn't guarantee you a recovery, even if you win, because they might not have assets. Very importantly, in the local courts here in the UAE, you cannot, well, under the law you can, but it never happens in practice. You won't recover your legal costs. So whatever you spend on lawyers and your own time and doing whatever else you want to do to investigate the whole thing, you can't get that back. You can get your court fee back for starting the case, and in Abu Dhabi there's no limit on the court fees. Of 3% of the claim value, uncapped. They used to be capped. In Dubai they're capped at 30,000 dirhams for any claim. So no matter what it is, it's 30,000 max. In Abu Dhabi it's 3% of whatever it is, and that can be a lot. Might not be, but you'll get that back if you win, and you can actually enforce your judgment. But you start to think to yourself, actually, if I wrote down what it's going to cost me, which you would do, and we would advise you on if we're dealing with a case for you, that's a big factor that makes you come back and think, actually, I'd be better off taking a haircut and getting away with this much if I can recover. It can be difficult. I say I won't go through all of them. One of the difficulties in this jurisdiction is it can be difficult to get settlements, because you giving concessions in writing actually can be used as evidence against you in a court case. If you sue someone in a defence, they may say, well, this person, we don't necessarily dispute liability, but this person's already said in writing that the debt, they'll accept 50%. That's an admission by them that the quality of what they provided was only, it's a variation of the contract, it's only 50%. There's something called without prejudice, which is a protection that applies to sort of settlement talks and written communications in other jurisdictions, which doesn't apply here. So you just have to be very conscious of what you do say in writing to people, where you're conceding something, or you could be conceding value or rights. If you're conceding interest, to say, well, I won't accept it. Sorry, I won't enforce interest against you. If you then go to court against them, they might turn around and say, well, look, they've already waived interest. You can't do that. Other jurisdictions, you might get protection for that. That wouldn't be allowed to be shown to the court.
Even if you bought without prejudice?
It won't matter. No. In the UAE civil courts, in the DIFC courts in Dubai, for example, that does have that principle, same as English law, so you'd have the protection. But always very careful of what people say in writing. That's why telephone, if you need to talk concession, offers, do it orally. When it comes down to actually coming to the nub of an agreement, obviously then it needs to be documented, and you might feel comfortable that you're there enough to be able to do it. Bounce checks, this is nearly the end. I know it's 10 o'clock. It is a criminal offence in the UAE to issue a cheque that upon presentation is dishonoured, which we call a bounced cheque is the common form. People often give PDCs, post-dated cheques, to guarantee either as the primary payment obligation, i.e. we pay you with this cheque and it's post-dated and that's what you use, or you get a cheque as security. So they say they will pay you, but they give you a cheque anyway as security for the event that if they default on the primary payment, bank transfer or cash, you can then have the right to present this cheque. Sometimes one of the best things you can get is sort of an undated security cheque, where you're not then limited by the validity of the cheque, which is 6 months. Any cheque written is 6 months, only valid for presentation for 6 months from the date you get it. So if you're taking PDCs, put those dates in your diary so that they flag up and say, I've got a month to go before this runs out. Because if you want to present it to the bank, you've only got that time. Otherwise, you've lost the security or the payment right. And you get 5 years from the date of the bouncing date in which to actually file a criminal complaint against the signatory of the cheque. And this is the point of who has the criminal liability. It's actually the individual liability of the signatory of the cheque, not the company. Even if someone's signing a cheque on behalf of a company, there's a separate civil liability for the company for issuing a cheque. That's a promise by the company to pay you, and you've still got your original contract. So you have a claim against the company under the cheque. But the main leverage really that people use, the threat, is the threat of criminal penal sanction, and that's against the individual. So you need to be thinking, if you're accepting cheques, who's signing the cheque? Is it someone who actually matters? Does the company care about that person? We've had instances of clients turning up. Yeah, the fall guy, exactly. We've had instances of clients say, well, look, we've got this, I think it was about a 3 million dirham claim in Dubai. Big client in the chemical industry, and they said, oh, we've got these cheques, great, we're going to file a criminal complaint against this guy. You know, that'll make them pay. Turns out they'd fired the guy who signed the thing, cast him aside, knowing that he'd been the cheque signatory. Criminal complaint went in. This guy poor guy gets hauled in. He's no longer with the company. He's sort of saying, it's not me. I'll give you, information you need. Please, can you stop this? Police don't automatically react. You have to file a complaint for the police to do anything, and you have specific sort of bounce check core expedited procedures now here in the UAE where particular departments will deal with it to try and get it processed, because it's almost it's seen as a strict liability offence. That's the way I describe it, where it's under the law you're automatically presumed to have acted in bad faith in giving a cheque, and there's either not enough money in the account. Basically, you're under an obligation to make sure that there is enough money for that to be paid on the date that it's paid, or that you maintain the bank account as being open. We often find that suddenly the cheque's rejected by a bank because they've shut the account down, and that's the same effect to the signatory.
And what if you cancel the cheque?
You can't. The bank wouldn't normally unilaterally accept a cancellation without the beneficiary agreeing to it. And if you did that, I think you'd have some kind of liability. You make the promise, you give the cheque, that's you made the promise, and your liability stems from that. Even if you turn around and cancel it, it doesn't absolve you.
Unless you find a police report, right?
Saying it's stolen, yeah, or it's been fraud, yeah, yeah. If you say that if there's a reason, a legitimate reason for you to do it, and that is, you say, oh, actually, we think this is a forged cheque, or it's been stolen, or something like that, then yeah. There's always exceptions to everything.
What if the cheque is returned because there is a signature mismatch?
Okay, if it's rejected purely, if it's rejected for a reason other than insufficient funds or account closure, there's exceptions which they're excluded from the criminal liability. So if it's the right person, the authorised signatory just doesn't quite do it right, and I've had that on some cheques that I've written in the past, where your bank calls you up and say, oh, we're rejecting a cheque because your signature doesn't match. Well, what's that going to mean for me? That doesn't bring criminal liability, because that's just sort of an administrative error that reasonably is recognised as you not acting in bad faith, provided the money's there.
What is the consequence of you being charged or convicted of having a bounce?
Normally, and I've got more experience with Dubai, you might know more in Abu Dhabi, Richard, to comment, but in jail in Dubai, if it's...
Immediately, regardless of value.
You have fines, but if the person hasn't got the money to pay, then it doesn't really help you. But you can be imprisoned for it. And there's debtors' prisons here where, because it's a misdemeanor offence under the law, which brings the 5-year time limit, those people don't get put in the same jails as sort of serious offenders, but it is a significant problem. And what you hear on the grapevine is that there are hundreds and hundreds of people in these debtors' jails for bounce check cases.
You can bail them, yeah?
No, not always. Well, what you get is, you see, it's your, as the holder of the cheque, the payee, you have the right to make the complaint to the police, okay? And it goes to the police, and then, they say it's pretty much strict liability, and unless there's some reason that you've described, a forgery or some other reason why it shouldn't be a liability, it then goes to the public prosecution, who then take it to court, and it's sort of pushed through. If during that process, from the moment of it bouncing, you reach an agreement and either the debtor or someone pays, you can then withdraw your rights, and because it's your personal right to do that. But there can be cases where, in the public interest, the prosecutor or the police might decide actually to proceed with it if it's aggravated for reasons of value or something like that, or the person who it is, or the way the transaction happened. There could be a reason why it does actually continue on, even though you've pulled your rights away from it. But my experience is, by and large, if you withdraw it, that's the end of it. So sometimes we've had cases where people actually get put in prison, and we'll still be negotiating with them on the telephone while they're in jail to get payment, because it's a bit of a difficult one, because sometimes it can hamper their ability to be able to pay you if they are actually put in prison. So if you have the bounce check in hand, you can say to them, it's already bounced, I can put this to the police now, but I want you to pay me. And if it still doesn't work, then maybe you will do it, and see if that changes their mind a bit. Because normally you find people will have contacts for lower values to be able to get the money together somehow. Higher amounts, maybe not. So that's the leverage. And when do you deploy it? When do you not? How far do you go? But it's nice to have it in hand already bounced, with no obligation on you to do anything with it within a 5-year window, and hold it. So yeah. Did you want to say anything about checks in Abu Dhabi?
Well, no, it's pretty much the same as it is in Dubai. Typically what the police will do is give you a call. They don't sort of actively go out and arrest people. They ask you to come down to the police station and answer some questions, and then they'll all take their passport. You take the debtor's passport at that point. So, normally my advice to somebody who's about to check is just to get out of the country at the first available opportunity.
Yeah, because
they can negotiate from abroad. The police will prosecute always, unless and until either the amount's paid or the complaint's dropped. And there is no indication that law is going to change anywhere in the near future.
One thing that reminds me of a point. There's two other points that sort of come on from that. One of them you alluded to. The police will sort of confiscate the person's passport while they're looking into the case, so they can't travel, which is good. And then if they're out of the UAE at the time and they can't be found, then the immigration stop will be put on so that they're sort of arrested on their way in. So that is actually very effective for people who have a lot of businesses here. And they might not just run that one. They might have others, like you mentioned. They might have other directorships. So they need to be in the UAE to do their thing. And if they're at risk of being stopped from doing that. We've got one today we're actually collecting. There's a criminal conviction against a lady's husband who was the director, and she was one of the joint shareholders but not a director, and the husband signed the cheque, and there's a criminal conviction against the husband who's out of the country, and we're negotiating with the wife for payment, and it's going to be because he needs to come back to be able to do, to live and to run their other businesses, and that's actually being used as a negotiation. And that's, I think, hopefully going to be paid today, with the lady coming in with money, and we're signing a waiver, and it's all going to be notarised and done. And that's probably about 50% recovery, which the client thinks is a good deal at the end of that, a couple 100,000 dirhams and it's effective. There is an exemption that applies to the criminal penal liability for UAE nationals where they've written a security cheque to a financial institution. So, sort of, few years ago, it was commonplace whenever you were taking a loan or something, the bank would ask you to write a blank security check, and you'll sort of nervously pass over an open check. That was, for financial institutions, that was sort of exempted from this penal liability for UAE nationals a few years ago. It doesn't apply to exempt them from checks provided in commercial arrangements, even if they're security checks. Sometimes people will try and say, oh, well, you can't, the UAE nationals are exempted entirely from this thing. That's not correct. It's only limited to financial institutions. We have found on some low value cases, the police, depends on which police station you go to, sometimes because they're misdemeanors, the police are sometimes a bit disinterested in actually proactively progressing this and going out and finding the person and arresting them in. Like you say, sometimes they'll call the person up and say, oh, we've just got a check, why don't you come in? We're not going to formally arrest you, but whoever makes your complaint on your behalf, you need to have someone, and we use our GLOs, PROs, who know the police, to go down with power of attorney or with the client and get the police focused on it. So here is where the person is, here's their numbers, here's their address. We'll even accompany you to where they are. Depends on how keen you are on it proceeding to actually get them hauled in. I mentioned earlier international trade, you're not really looking at checks, but because of all this, if you can get a PDC as part of your package, often it can be an easy concession for you. You just say, I demand, we're not going to settle anything unless you give us PDCs, and eventually they say, no, we won't, and then you concede that point back at the end. So you can sort of put it out there as a strong thing, we absolutely want it, and if they won't give it, and you're willing to go ahead without it, and you can say, okay, to do a deal, I'll concede that PDC requirement. Really what this slide was to summarise with examples, which I've pretty much done as I've gone through in terms of certain things that we've seen happen, particular examples of those points. I've done that as I went through, yeah.
When a client comes in that you don't know and they have a standardised, they're a creditor, what ballpark threshold do you have below which you say, look, it's probably not proportionate for you to engage me and my team?
For me,
Yeah.
personally, we apply a $10,000 debt value threshold generally. It's not absolute, not set in stone. That is because we do it on I can show you the thing. The team that I run, so this is where we come back to in the end, is sort of how can we help you, is we call it Collect the service. So it's run by a lawyer, me, and I supervise a team of non-lawyers who are sort of credit control background, but they've been working in the law firm for several years, and they're a bit more sort of advanced on the legal side of things. We do it on a contingent basis, so we'll take a small fee to start with, sort of generally $500, and a cut of anything that we recover before litigation. Because it's illegal here to act on a contingency fee basis in litigation. Lawyers can't say, we'll take X% of damages. Can't do that. So we can do it if you're not in litigation. So that sort of means that the creditor knows that really they're not paying anything other than the small fee at the start, unless they're getting money through the door. So it's a win-win, low-risk thing. But because of that, it has to be economical for us. $10,000 is the average benchmark, below which we'd be losing out no matter what happens. Even if we recovered 100%, we'd still not get our time back. And lawyers are all about how much time you spend on cases and what your cost would be. So yeah, $10,000. But what we sometimes, that's on a one-off case basis. If, as happens regularly, a client will come to us and say, well, here's 50 cases that we've got on our debtor ledger, varied all over 90 days, so they're our problem ones, and here they all are. We'll do some kind of package where it's not 500 for every one of those, it's a much lower overall aggregate figure, and maybe a percentage different, or depends on the whole value, but there's ways we can do it for you that maybe change that for individual debts if it's worth it for us. So that is it really. Thank you for listening. If you have questions, I've gone over slightly.